Welcome back. Previously on 516, we've thought about some common perceptions about the First Testament and the significance and the unity of the collection of these 39 books by our English reckoning. And then we've taken a 5,000-foot view of the setting, the storyline, and some key concepts. And now we want to think a bit about how do we understand the meaning of the text. Have you ever spoken or taught through an interpreter? What was that like? What was going through your mind when you spoke 4 or 5 sentences and paused for your interpreter and they spoke maybe 10 words? What went through your mind? Or conversely, you said just a phrase and they went on and on and on. That can be a little disconcerting. But this is a real life issue. I've experienced cases where I spoke too long without a break and probably lost my interpreter because when it was their turn, they took but a few seconds, and I thought, I think something's been lost in translation. And then there was the occasion where I was diligent about delivering very concise thoughts and pausing to let the interpreter have at it, and my rather brief thought was turned into a monologue that seemed to go on, and I worried about what the interpreter was making up. Well, as an interpreter of Scripture, I do get concerned about my claiming something that's just not there. Or, on the other hand, about glossing over something that is there. In the Christian community, it can manifest itself like this pastor's testimony. He said, I did a 6-month series on John 3:16. I did a sermon on the word that. You see, you have to ask questions. He says, some Christian traditions think that a text has a meaning, and if you apply the right method, then you can pull out the correct meaning. He concluded, that's the ultimate arrogance. See, if it's a living word, then you've got to turn the gem. Well, I can only conclude that here's an approach that turns the text inside out. So, how am I to understand the Tanakh, the Hebrew Bible, the Old Testament, the First Testament? Let's think a bit about authorial intent. I know that you're at least familiar with the Oxford University professor of math and logic, Charles L. Dodgson. He wrote Symbolic Logic, in which he argues that I maintain that any writer of a book is fully authorized in attaching any meaning he likes to any word he intends to use. If I find an author saying at the beginning of his book, let it be understood that by the word white, I shall always mean black, I meekly accept his ruling, however injudicious I may think it. Get that? It's the author's prerogative, but he must use the term consistently. This is called the doctrine of stipulative definition. But, and here's the rub, for communication to take place, there has to be a commonality between the author, the speaker, and the reader or the audience. Now, I don't want to fog up the point by having you silently resisting my claim that you're familiar with this logician, so let me remind you that in his spare time, Dodgson enjoyed writing stories for the children of his pastor, Henry Liddell. And he happened to write them under the pen name Lewis Carroll. And he teaches the little children the same point by way of a dialogue between Humpty Dumpty and Alice. Listen for it.
On birthday presents. You see, dum-dum?
Certainly.
And only one for birthday presents, you know. Now, there's glory for you.
But I don't know what you mean by glory.
Of course you don't, till I tell you. I mean, there's a nice knockdown argument for you.
But glory doesn't mean a nice knockdown argument.
When I use a word, it means just what I choose it to mean. Neither more nor less.
The question is whether you can make words mean so many different things.
The question is, which is to be master? That's all. Words have a temper. Some words particularly. Verbs, they're the proudest. Adjectives, you can do anything with, but not verbs. However, I can manage the whole lot of them. Impenetrability, that's what I say.
Would you please tell me what that word means?
Now, you talk like a reasonable child. I meant by impenetrability that we've had enough of that subject. And it would be just as well if you'd mention what you mean to do next, as I suppose you don't mean to stop here all the rest of your life.
That's a great deal to make one word mean.
When I make a word do a lot of work like that, I always pay it extra.
Did you hear his argument for authorial intent? Well, maybe another case for us to study might be the contemporary debate about constitutional law and the hermeneutics of Supreme Court justices as they exegete both apodictic and casuistic law and the Constitution. How does one read the Constitution? Do you eisegete, lead meaning into the text, or exegete, lead meaning out of the text? I agree. The significance of the Constitution is multiplex, but is the meaning of the Constitution malleable? Now, this isn't uniquely a 20th century issue in American jurisprudence. The fourth Chief Justice, I should say, John Marshall, who's the longest serving Chief Justice. He was the chief from 1801 to 1835. He argues that the framers' intent trumps. Listen to what he writes in a Supreme Court opinion. Although the spirit of an instrument, especially of the Constitution, is to be respected not less than its letter, yet the spirit is to be collected chiefly from its words. And it would be dangerous in the extreme to infer from extrinsic circumstances that a case for which the words of an instrument expressly provide shall be exempted from its operation. Where words conflict with each other, where the different clauses of an instrument bear upon each other and would be inconsistent unless the natural common import of the words varied, construction becomes necessary. And a departure from the obvious meaning of the words is justifiable. But if in any case the plain meaning of a provision, not contradicted by any other provision of the same instrument, is to be disregarded because we believe the framers of that instrument couldn't intend what they say, it must be one in which the absurdity and the injustice of applying the provision to the case would be so monstrous that all mankind would without hesitation unite in rejecting the application. Now I realize that's a little bit of legalese, and it's also not the kind of English we speak or write nowadays, but you get the point. The authorial intent, the natural reading of a text, that if we want to do something different with it, that reading, that understanding has to be so outrageous, so egregious that everyone would agree that can't possibly be what they meant. Now let's fast forward almost 200 years, and the debate still rages. Listen for the core hermeneutical issues raised by Justice Antonin Scalia on the present court.
Segment 2, The Originalist. Justice Antonin Scalia, quote, "The Constitution that I interpret and apply is not living, but dead." Close quote. Explain that one.
Much of the harm that has been done in recent years by activist constitutional interpretation is made possible by a theory which says that unlike an ordinary law, which doesn't change, it means what it meant when it was enacted and will always mean that. Unlike that, the Constitution changes from decade to decade to comport with, and this is a phrase we use in our Eighth Amendment jurisprudence, the court does, to comport with, quote, "the evolving standards of decency that mark the progress of a maturing society." In other words, we have a morphing Constitution. And of course, it's up to the court to decide when it morphs and how it morphs. That's generally paraded as the, quote, living Constitution. And unfortunately, that philosophy has made enormous headway, not only with lawyers and judges, but even with John Q. Public.
Two quotations. Lord Denning once again, and I get this from...
Why do you keep throwing him at me? He's not one of my favorite jurists.
Because you quote him in the book. He does the job, and you'll see what the job is in just a moment. Two quotations. Lord Denning, great British jurist, quote, "The proper role of a judge is to do justice." Justice Antonin Scalia, quote, "The ideal rule for the honest judge is garbage in, garbage out." Close quote. Explain yourself.
Well, I'll answer Denning with Holmes. Holmes.
So the great Associate Justice.
Yes, Oliver Wendell Holmes, and a woman, as he was passing by, cried out, "Do justice, Mr. Holmes!" And Holmes is supposed to have replied, "I don't do justice, I apply the law." And applying the law is justice because it's not supposed to be up to the court what justice consists of. That's a matter that's decided upon by the people, democratically. And the good judge in a democratic society is not the judge who has a better sense of justice than other people. It's the judge who can better perceive the meaning of legislative enactments than other people. And that's what a judge in a democratic society ought to be doing.
Your colleague on the court, on the Supreme Court, Justice Stephen Breyer, quote, "Judges all have 6 tools: text, history, tradition, precedent, the purpose of the statute, and the consequences, policy consequences he's referring here, of the decision in question. Some emphasize the first 4 and try to avoid the last 2. They think that in doing that, it's less likely they'll get subjective," close quote. The argument here is that originalism is not a distinct interpretive doctrine, but merely a matter of nuance and emphasis. You apply certain rules a little more often than others and avoid some rules a little more often than other justices.
No, that's just not true. I will apply the original meaning once I'm persuaded that is what the people understood when they adopted this constitutional provision. I will apply it even if I don't like the result. What are the last 2 he mentions? Consequences and what else?
He's got here the purpose of the statute, intent, legislative intent, and the consequences. By the way, we shouldn't hold him to a high level for writing because this is something he said extemporaneously. He was in a debate with you as it happens.
Yeah. Okay. I wasn't paying attention, I guess.
All right, what the people understood. Here's a question. Administration of George Washington, first president. Treasury Secretary Alexander Hamilton wants to establish a national bank. And the founders themselves disagree vehemently over the constitutionality of doing so. George Washington, who presided over every session of the Constitutional Convention, and James Madison, the principal drafter of the Constitution, were at loggerheads over the constitutionality of a national bank. Now, what is a poor little layman like Robinson to think of originalism when it's historically clear that, now, as far as I know, there are not a lot of cases like this, but here you have two of the key figures involved in drafting the document who disagreed over the meaning?
Look, I do not propose or suggest that originalism is perfect and provides easy answers for everything. But that's not my burden. My burden is just to show that it's better than anything else. And the originalist has easy answers for many things, especially the most controversial things in modern times, whether the Equal Protection Clause requires that the states permit same-sex marriage. I mean, you know, that's not a hard question for an originalist. Nobody ever thought that's what the Equal Protection Clause meant. And it didn't mean that when it was adopted. It doesn't mean that today. It doesn't change to mean that just because the Supreme Court thinks it's a good idea. Whether there's a right to abortion. For Pete's sake, it was criminal in every state for 200 years. Now, if you want a right to abortion, create it the way most rights are created in a democracy. Persuade your fellow citizens it's a good idea and enact a law. But don't tell me the Constitution confers such a right. So I have easy answers to a lot of stuff. Whereas, for the living constitutionalist, there are no answers. Every day is a new day. I have sat with 4 colleagues, one still on the court, 3 since deceased, who thought that the death penalty was unconstitutional. It's mentioned in the Constitution, but every day's a new day. And you know, it used to be constitutional. Maybe tomorrow it won't be.
What do you make of his argument that a text means what it meant when it was enacted, and it will always mean that? Or to run that through the ringer backwards, you can do as you wish, but a text doesn't mean what it never meant. The theory that the meaning of a text changes, that it morphs from decade to decade to comport with evolving standards that mark the progress of a maturing society. Remember earlier we made reference to Goldsworthy's observation of this evolutionary phenomenon with respect to Scripture. Scalia argues that he would apply the original meaning once he was persuaded that that's what the people understood when they adopted this constitutional provision. Well, the point I want to make is that when everyone's watch tells the right time in his own eyes, then everything's up for grabs, and I agree with Scalia. Every day's a new day. But then Scripture's not really Scripture anymore. And it certainly isn't going to work as one's final authority for faith and practice, what one believes and how one lives.